Welcome back to Supreme Myths. This is the 30th episode of this podcast, and I can't think of a better person to have on the 30th episode of this podcast than my friend Sandy Levinson, the W. St. John Green Garwood and W. St. John Garwood Jr. Centennial Chair in Law at the University of Texas. Sandy has the longest chair name of anybody who's been on this podcast. You probably know who he is already, of course, but Sandy is the author of over 400 articles, essays, and all kinds of things. Too many books to mention, including one of the most famous constitutional law case books. He blogs at Balkanization, and he also is the co-writer, I believe, of a play, which we're going to talk about later on in the podcast. I just want to say something personal. Just last week, a student said to me, "Who have been your three biggest influences in your career?" And in no particular order, I said Judge Posner, Mark Tushnet, and Sandy Levinson. And I mean that very, very sincerely.
Thank you.
Sandy, thank you for being here.
My pleasure.
I really appreciate it. So let's start with this. You were one of the first people, I think, in the law school culture that I'm familiar with to really talk about how stupid much of our Constitution is. And you said this before Trump. This is not a reaction to Trump. This is Why don't you give us 3 or 4 examples of what you think are the most important stupidities in our Constitution?
Sure. I mean, it'd be interesting, actually, to compare whatever I say now with a lecture that I gave at Georgia State back in, I think, the winter of 2000.
You were definitely sick. That's what I remember.
Yeah, what I remember most vividly is that I got on the plane with flu, and it really didn't get any better. You
did a great job. You did a great job.
And so the answer I would give inevitably depends on when you're asking it, and that's why it might be interesting to look back at the answer I would have given 20 years ago. Today, I think the stupidest features, not necessarily in rank order, but the first, I'll give you 4. Article 5, because it infantilizes us not only by making it very difficult objectively to amend the Constitution, but it also discourages any serious discussion about constitutional amendment because it seems just futile. We live lives of scarcity in terms of time, money, and energy. And why would you put that into a serious campaign for constitutional amendment if you thought it was going to fail? It's really as simple as that. And I would contrast this with almost any of the state constitutions. And one of the things that's probably truer now than 20 years ago is that I am much more interested in state constitutions than I used to be as part of a general interest in comparative constitutionalism. And it's really important to realize that American state constitutions are really quite different from the national constitution. And one of my aspirations is to get students to argue with one another about whether the Georgia Constitution or Texas Constitution is better or worse in some particular feature than the U.S. Constitution. And I think that all of the U.S. state constitutions are better than the U.S. Constitution in terms of constitutional amendment. So that's 1. 2, because of what's happened in the last 20 years, well, what's happened really in the last 2 years, I have really grown to loathe the impeachment clause because it is clearly inoperative. And I think the reason it is inoperative, and I'd be interested in your own reactions on this, is that it's been captured by lawyers. And what that means is that debates about impeachment turn into shouting matches about what counts as a high crime and misdemeanor. Whereas I think impeachment really ought to be a vote of no confidence. That is, it ought to be much more political. And we ought not be embarrassed by making it more political. If you go to sleep at night terrified that you're going to wake up and find that somebody is still president, that's a good reason to want to fire the person. it really doesn't matter whether or not he's a crook. The most serious thing about Richard Nixon was not that he was a crook. The most serious problem with Donald Trump was not that he stiffed a lot of people in contracts, but impeachment really, as I say, has been captured by lawyers. And lawyers are addicted, as you know better than anybody, because this is one of your own emphases, are addicted to the law politics separation, so that we shouldn't taint discussion of impeachment with anything that sounds like a political consideration, such as the fact that the person is unfit to be president or merely displays such appalling judgment that you want that person out. So that's number two.
Sandy, hold on. Let's pause on those two things for 1 minute, and then I'll ask you for 3 and 4 in a minute. On the first one, a lot of my students are always surprised when they learn that the Georgia Supreme Court struck down Georgia's anti-sodomy between two consenting adults in a private room. Before the Supreme Court, after Bowers and before Lawrence, it was the I'm talking Georgia here, not New Jersey, that struck down that. And there are other things the Georgia Supreme. I know a lot of the Georgia Supreme Court justices, and leaving aside legal talent, they are generally more attuned to real life considerations than the Supreme Court of the United States. So I couldn't agree with you more about the importance of state constitutions. On the impeachment issue, and you don't have to comment on this if you don't want to. I always say that you can stay silent on this. I think Jonathan Turley is a great example of what you're talking about. There was a time when Jonathan Turley was a real scholar, and I respected his work, and I still respect some of what he says. But Fox News shone the spotlight on him, and now I just view him as someone who loves the spotlight. So, go ahead, sir.
But, I mean, in semi-fairness to Jonathan, it's also the case that the liberals who testified in behalf of Trump's impeachment, who are friends of mine, nonetheless took up valuable time in discussions of 17th and 18th century English practice on impeachment and originalism that both of us would agree is really beside the point, even if one took originalism more seriously than either you or I do. But it just was infuriating to see somebody with the talents of Noah Feldman and Pam Carlin, I think Mike Gerhardt, I think he was the third one, all of whom are extremely able, all of whom broadly share what I take to be our general politics, reduced to offering what Antonin Scalia would have called argle-bargle in terms of discussing whether Donald Trump is fit to be president.
It's insane. I actually wrote a blog post about that. I use Noah Feldman. I've gone between casebooks in the past. I have used yours in the past, but right now I'm using Noah Feldman's, and I like Noah. All three of, and I love Pam, of course, and Michael's a friend of mine. All three of them, I wrote a blog post saying, what were they doing there? Why did they think they should be there? That was my position.
So, moving on, just to finish 3 and 4, the Senate, in many ways ought to have pride of place. There is, I think, no defense of the Senate. Here I will become quasi-originalist because I always point out whenever I can that James Madison detested, at least in 1787, detested equal voting power in the Senate. He described it as an evil. I always go on to say he described it as a lesser evil because it was the compromise price necessary to get a constitution. But what I always point out is that the other central compromise that's never honored with capital letters as the great compromise was slavery. And we are living adversely with the consequences of the compromises over slavery and the compromises over the Senate. So, the Senate is just terrible beyond belief. And then, it's embarrassingly low hanging fruit, but the Electoral College always deserves to be listed in the greatest none hits. Both of if I can add a fifth, because I'm sure both of us agree, is life tenure, especially on the Supreme Court. I'm much more agnostic about life tenure on federal courts in general, but I think that it is an idea whose time has long since gone in terms of being defensible.
Yeah. On the life tenure point, of course, I agree with you 100% on that. I was thinking about Justice Breyer today because he gave a talk yesterday at Harvard. We're taping this on Wednesday. It won't come out for a few more days, but Justice Breyer gave a talk yesterday at Harvard at the annual Antonin Scalia lecture, which I think was funded by all kinds of dark. There's a whole story there too, but leaving that aside, but Breyer was warning the liberals not to do court reform because that would turn the court into a more political institution than it already is. And I thought, let's look at the world when you were confirmed, 1994, I believe. I mean, there wasn't even an internet, really. I mean, it was, but not like today. And he's still on the bench. That has to be crazy, yes?
Right. I think one can agree with Breyer and then use the expression that my friend Jack Balkin often uses in this context. So what's your point? Because what Breyer wants to resist, and frankly, I think he wants to resist it not because he's, being cleverly political. I think it's actually his worldview. I do not think you can, disregard the fact that he was educated at Harvard in, I think, the late 50s, early 60s.
Yeah.
He is a veteran of the Hart and Sachs approach to trying to respond to American legal realism by creating what I, again, suspect that both of us agree is this fantasy of a legal method, a legal process that is sufficiently divorced from politics that we can continue to venerate it. And that, I think that is the way that Breyer thinks. So I don't think he's a cynic, but I do think that he is missing the point that the Supreme Court, especially, has always been, from the moment that John Adams appointed the midnight judges, and particularly John Marshall, to be Chief Justice, has always been up to its neck in politics. And the question is whether that understanding ought to be limited to the cognoscenti like us, or whether, the people in general should realize that the court is a very special political institution. Now, where you and I might disagree is that I think the court, in fact, can and on occasion has played a valuable role. But that doesn't reduce at all the fact that the role it's playing is a political role. And as you know, I have grown, much to my surprise, to share your esteem for Richard Posner, especially what I will call the late Richard Posner. Now, that is the late
Yes.
in his career,
Yeah.
since he's certainly still alive.
Sandy, I have to interrupt for 1 second. I'm sorry. So I am criticized on social media every day for talking too much about Richard Posner, and I want to be clear that you brought him up, not me.
Yeah, no, I very happily brought him up because I really do have great esteem for him. But part of what I esteem in him is that he is probably the only judge in the history of the world who has written a book called Overcoming Law, and who, you know, is open and above the board. And I think he's very similar to Breyer. incidentally. I think that he is a, well, I've defined Posner as a right-wing crit, but I think that what ties Posner and Breyer together is that both view the role of the judge as genuinely trying to make the country better and not paying all that much attention to legal formalism
Yeah.
by way of doing that. Posner at times would pay no attention to it. Breyer pays somewhat more attention, but neither one of them is the child of Christopher Columbus Langdell. Um, and Breyer's a technocrat. And so I think at heart is Posner. And so we can have a genuine debate about whether there is a valuable role for an institution that is political but less political than the US Senate, in part because once they're appointed, they don't have to run for reelection and they have life. I wish it were only 16 or 18 years, but they have, a good amount of time to instantiate their vision. And then we can argue whether that's a desirable institution or not. I don't think that's an argument that Breyer really wants to have, though to his credit, he's written now a couple of books about the Supreme Court that I think makes sense only if you realize that judges bring to them, as Felix Frankfurter argued back in 1933, and even before that, but this is an essay in the International Encyclopedia of Social Sciences, where he said judges bring to the court idealized pictures in their heads of how the political system should operate.
Right.
And that seems to me clearly, obviously true. There's no serious argument about that.
So, Sandy, one of the things that before retired Judge Posner left public life, he kind of went after the Supreme Court pretty harshly. He went after Scalia, and he went after the whole. But he never went after Breyer, and he told me that Breyer was on many occasions that of the current court, that he thought Breyer was A, his favorite, and B, maybe the smartest. Before Kagan got on anyway, maybe the smartest justice on the court. He had a lot of respect for Breyer, which is kind of interesting.
Smartness is interesting in this context because, one of the banes of legal education is how we define smartness, what grades are based on, what law reviews look like. So, I don't know how smart Breyer is. I'm sure he is very smart. I think that actually most of the justices are very smart. I have no reason actually to believe that Clarence Thomas isn't very smart. I think that partly by his own disastrous decision to portray himself as a fool in his confirmation hearings, where he said, well, I've never talked about Roe versus Wade, or I gave these speeches, but I really didn't write them. That, I think, disserved him. And I think that he is also the victim of a certain amount of racism in being dismissed. That being said, I wish he weren't on the court. I would have voted against him before Anita Hill. I think it's perfectly proper to take ideology into account, but I don't think Clarence Thomas is dumb.
No.
So then it's a question of what kinds of intelligence people have. And, I think that Breyer and Posner had a kind of intelligence that serves the country better than the kind of intelligence that will get you A pluses at some of our finest law schools.
Right.
because you can case crunch in certain ways. Um, and, I have become more and more a critic of legal education in my sunset years. And when you introduced me, I do have that long title, and I'm extremely grateful to the Garwood family for, helping to subsidize me.
Yes.
But I also increasingly emphasize that I also remember the government department at UT. And I would say that in my sunset years, I do identify at least as much as a political scientist, though I'm much better paid than almost all political
Yeah.
scientists are,
Right.
than a law
Well,
professor.
I think that's one of the reasons one of the many reasons I've admired your work over the years, because you come at this as much as a political scientist as a lawyer. And that I think that is, when we're talking about the Supreme Court, I think it's really important. Can I tell you where Breyer lost me? And I've mentioned this once before in a podcast, I forget with who. So he voted to uphold every affirmative action law he's ever seen, except the one in Gratz, which was the same day as Grutter.
Yeah.
And in that case, all he does is drop a footnote where he basically says, I agree with Justice O'Connor's decision striking down the affirmative action plan, except to the extent that it says anything. And then he says, I agree with Ginsburg's dissent completely, except for its conclusion. And I have always thought, and this recently was confirmed to me by someone who knows him, not Posner, that he probably did that to protect Sandra Day O'Connor, who was his really close friend.
That would not shock me, nor would it necessarily appall me. My response to the political critique of the court is not to say, oh, we have to try to remove any taint of politics, but rather to say, okay, we recognize there are these, political aspects of the court. Are we well served by them or not? How might we redesign it to be better so that, talk about reform, Breyer's talk. He is thinking about court packing.
Right.
And I quite frankly am, far more sympathetic to court packing than he is. But what I posted this morning on a listserv that both of us are on is my reservations about the Supreme Court's control over its own docket, which is just another example of congressional delegation. It goes back to the Cert Act of 1925 that Chief Justice William Howard Taft lobbied for. And over the years, Congress has been ever more acquiescent. My view is that we might well be better off if the Supreme Court lost control over its own docket, and if, for example, we had a specialized cert court, and then we could debate about how that court should be
I've called
composed.
for that, Sandy. I've called for that. I think it's a great idea.
So, we could also talk about...
I'm sorry, let me interrupt you one more time. That 1925 law you just mentioned, there's a law professor at Penn State, and I'm going to forget his name, and that's just having a senior moment, who has written a fantastic article. That law gives the court its certiorari discretion over cases, not issues. And this law professor at Penn State has made the argument, when the court takes a case and says these three issues, that flatly violates the statute. And any issue in the case should be fair game, because they only have jurisdiction over cases, not under the clear terms of the law.
Okay, so now you're retreating to legal formalism. How do you explain Breyer's vote in Sebelius? That, where he agrees with Roberts that the Medicaid expansion is unconstitutional. Kagan, of course, voted the same way. One answer is I have no idea.
No, we do, Sandy. We know. Sandy,
voted.
I'm sorry. We now know. We now know. I mean, Roberts' biographer.
Okay. No idea is an exaggeration.
Okay.
I I don't have dispositive evidence,
Okay.
but it seems to me highly likely that Breyer and Kagan were playing the long game and might have simply underestimated the degree to which crazily Republican states would turn down the deal,
Right.
as Texas did. I think Georgia
Yes.
did.
Yep.
That Republicans would rather see people die than warrant Obamacare. I don't think that that was so obvious in 2012.
Yep.
And I think that Breyer and Kagan thought that Roberts had taken one for the team in switching his vote, or apparently switching his vote, with regard to the mandate and coming up with his tax rationale. Um, and so, you can either be shocked that they would have done this, or to say, okay, what were they thinking? And on balance, do we think they're glad or sad they did what they did? Now, the fact is, it wouldn't have mattered had they gone with Ginsburg's dissent. Roberts still would have prevailed, and Texas still would have been able to say no to Medicare. So, I mean, the most unfathomable of Breyer's votes to me is the one in an automobile stop case from Utah a couple of years ago, where the Utah Supreme Court, and this again gets to your point, that we, and by we, I will say broadly, political liberals or law students either don't know anything about state courts or automatically assume that state courts are going to be Neanderthal and it's the federal courts that are enlightened. The Utah Supreme Court protected the driver who was stopped, said it violated the Fourth Amendment. Unfortunately, they didn't say it violated the Utah
Right.
Constitution. They said
Right.
it violated the Fourth Amendment. And then Breyer supplied the fifth vote in an opinion written by one of the conservatives. I don't think he wrote the opinion, but I know that he was the fifth vote.
Yeah.
And so there I had to ask, what was he thinking? And I have no idea.
Well, it's interesting you mentioned that, because Justice Stevens, who's probably my favorite justice, give or take, in Michigan versus Long a long time ago, said, this goes back to your point about the discretionary docket and the court has complete discretion. That was a case where the Michigan Supreme Court had interpreted the Fourth Amendment liberally to let somebody out or something. And the court reverses, and Stevens says, why are we doing this? If Michigan wants to let him out, why are we overturning Michigan? And why are we taking this case? It's a huge, it goes right to your point.
Right. Yeah, I mean, this touches, I don't know whether you want to go down this road or not, but it touches on the degree to which, or I should say, when the court professes to take federalism very, very seriously,
Right.
and when it very clearly just couldn't care less
Right.
about federalism.
Right.
And this is a very, very interesting example.
Yeah. Let's talk about the court for a minute before we get into legal education. So I will never forget, I don't remember when it was, but it was at least 5 or 10 years ago. I had asked you to look at something or be involved in something. You've always said yes to me in everything I've ever asked you to do. But this was a very doctrinal thing. And you very nicely and politely said to me, Eric, I just don't have any interest in getting into debates about, constitutional doctrine. I did that for a long time and I'm done. Can you talk about that a little bit?
Yeah. I think what you say is more or less true. I think probably one could say that my métier has never been constitutional doctrine.
Sure.
Though I would say to anybody who, accused me of, not being able to do it at
Right.
all, I would say that in many ways, the high point of my legal education at Stanford was working with Tony Amsterdam on a cert petition to the Supreme Court. And Tony, as you know, is one of the all-time great
Yep.
doctrinalists.
Yep.
And I certainly read every case I could get my hands on, and in a kind of struck by lightning fluke, I actually got a case that started out in the Princeton Traffic Court to the US Supreme Court.
Wow.
And so I had my moment of arguing before the Supreme Court, and I wrote a highly doctrinal brief. And so I think I can do
And I wasn't
doctrine.
suggesting you can't do it. I was
No,
suggesting you
no,
don't
no,
want to do it.
but I would also say, and more to the point of your question, it's not something that I find compelling as a use of my increasingly scarce time.
Yeah.
I think that one of the reasons, to be perfectly blunt, is that in my old age, I want to read first rate or even second rate stuff. And most of what the Supreme Court is doing is third or fourth rate,
Yeah.
partly because the opinions are written by law clerks who have been trained at our nation's finest law schools to do case crunching and nothing else. Partly because, especially majority opinions, are horses designed by a committee. And so they almost inevitably will come out looking like camels. And so you wonder, well, does this really make sense? And the answer is no, but it was the price of getting a fifth vote.
Right.
So, to take Scalia's opinion in Heller, for example, of which I'm not a fan for many reasons, though I think the result was right. But Scalia simply announces as an ipse dixit that every existing national law restricting firearms is constitutional. He doesn't give you the slightest clue as to why that's the case, other than, actually, he doesn't give you the clue. The externalist suspicion is that it was necessary to get Anthony Kennedy's fifth vote.
Right.
And a vote for the majority opinion rather than a patented concurring opinion by Kennedy, as in parents involved, that makes no sense, but it does have the virtue of stripping Robert's opinion of the status it would have had it been a majority opinion instead of, I think, merely a plurality opinion for four.
I think Obergefell is the same. I think the
Oh,
liberals.
Obergefell, that it is, from one perspective, inexplicable how Kagan and Sotomayor could have signed on to that opinion, because I teach Kennedy's opinion as a truly Catholic opinion
Yep.
that argues basically that if you don't have the discipline to be a monk or a nun, then you must be married in order to have a fulfilled life.
Or you will, or the line is, you will call out into the darkness and nobody will answer.
Exactly. And I don't believe that is Sotomayor's or Kagan's view of themselves. I think that the decision rule for them was whatever Tony wants, Tony gets.
Yes.
And I don't have any hesitation in were I to teach Obergefell, and I no longer teach introductory common law, I would have no hesitation in saying that. And for that matter, in defending it, that better to have Obergefell, even as a majority opinion, even if it doesn't make much sense in a number of ways, than to have Kennedy's opinion as only a plurality opinion, and then the need for these concurring opinions to get to number five.
Either Kagan or Ginsburg said that after the fact. They kind of they gave one of them gave an interview and pretty much said, we decided one unified decision, even if we don't agree with every sentence, would be better. So Sandy, I want to ask you a very selfish question. Many years ago, 2013, I think, you were very kind to be on a panel on my book, Supreme Myths: Why the Supreme Court is Not a Court, in Hawaii. Actually, it was fun to be in.
Yes.
And one of the things you said at that panel, I want to ask you about today, because it's been 8 years now. You said to me, you didn't really have an issue with my descriptive account. Where you did disagree with me was that the Supreme Court was in any way that's serious different than other state Supreme Courts or appellate judges where there's no precedent in how they handle legal issues. And I responded, I don't agree with that. I think a perfect storm of events has made the Supreme Court a unique political institution, legal institution in the world for a lot of reasons. Do you still think that the court is not really that different than those other courts?
Probably not. I mean, clearly the Supreme Court has more open freedom than an appellate court. Now, one can argue that appellate courts can be very wide-ranging indeed in the way they use their power, knowing, among other things, that literally 99% of Court of Appeals decisions are final decisions. And if you are a rational choice buff, you actually realize that your decisions aren't going to be reviewed. You can pretty much do what you want, though there's always the possibility that the court will take a case.
Yeah.
I don't know that Posner spent much time worrying that the Supreme Court would monitor him.
Well, let me say on that point that Posner and I had a debate in the Cardozo Law Review where he took your position, where he said the Supreme Court really isn't that different because 99.9% of the time I don't have to worry about them. To which I responded, I'm curious your opinion about this, to which I responded, but you, Posner, were very critical of Heller in every imaginable way and publicly the day it came out. And a year later or 2 years later, you struck down an Illinois gun law, which you wouldn't have voted to strike down were it not for Heller.
Okay, two things. One is the language that the judges feel free to use in their opinions. And it's just the case that no, quote, inferior judge, unquote. No is a little exaggeration because you can find an exception or two. Almost no inferior judge will say, I am overruling what I think to be a dreadful decision by U.S. Supreme Court.
Right.
They all feel it necessary to be doctrinalist, which is why I wrote something, at least 20 years ago in a Federalist Society journal, that the whole debate about originalism is completely and utterly irrelevant, except for the Supreme Court.
Right.
Because if you go before an inferior court, unless it's a fabled case of first impression, you're going to spend your time case crunching. And if you tell the judge, Your Honor, this case is wrongly decided because James Madison would have been called, which might be true, the response of the judge, and the judge will be chastised if this isn't the response, is my job is to be the faithful agent of the Supreme Court. It's not to overrule the court.
And by the way, Posner
And
believed that. Sandy, Posner believed that 100%.
right, right. So then you get to, why did Posner write the decision he did in the gun case? Is it because he viewed himself as under a duty to be a faithful agent of people he really didn't respect?
Right.
Or is it that he was engaging in what David Posen and Jessica Bowman Posen might describe as uncivil obedience? That is, reading the Heller case kind of for all it's worth and saying, okay, are you willing to take responsibility for this consequence,
Right.
which seems to follow, and which is really, although he doesn't quite say this, really quite counterproductive from a social policy point of view. I mean, I think the greatest, I think it's an 11-page appellate opinion of all time, is Frank Easterbrook's opinion for the Seventh Circuit in McDonald,
Yep.
where he says, even given Heller, we don't have to incorporate the Second Amendment against Illinois, not only because reasonable people can believe there ought not be one single national solution to the issue of guns, but because, hey, some of us believe in federalism.
Right.
And so,
Sandy, I got to go back to something you said. Otherwise, people will kill me. You said you thought Heller was, the result was right if the analysis was wrong. I want to make sure I understand what you mean by that. I take your writings to be that we can get to a right to own guns in various different ways using the 14th Amendment, not using the original Second Amendment. Is that fair?
or using the Ninth Amendment.
Okay.
That
Okay.
it is, I think, completely respectable to argue that by the mid 19th century, both Roger Taney and Charles Sumner agreed that if you were a U.S. citizen, you had a right to keep and bear arms, period. I think this is why Taney believed that blacks could not be citizens, because it was unthinkable to him that blacks could have a right to bear arms.
Right.
And why Sumner, in his Bleeding Kansas speech, said, of course, anti-slavery settlers in Kansas should have a right to bear arms. This has nothing to do with serving in a militia. And I think you could also make arguments that, for better and for worse, I think as a society we'd be better off if there were no firearms. But that's not the society we live in.
Right.
I think that it is crystal clear that most Americans do believe there is some kind of right to bear arms. And frankly, one of the things I find so fascinating about Heller, particularly for people like you and me, who identify ourselves with legal realism
Yes.
in one way or another,
Yes.
that if the question self-consciously before the judges had been, what will serve the interests of my party, then Heller would have come out the other way.
Right.
That is, the Republicans would have realized that it's a winning issue for the Republican Party to say, we protect guns, and these liberal Democrats really do want to take your guns away, which a lot of liberal Democrats do. On the other hand, the liberals who dissented would have said, look, we have this once in a lifetime candidate named Barack Obama, who, might actually become president. but he's never, ever going to become president if he has to spend all of his time explaining either why he agrees that if the legislatures want to, they can take away your gun rights, or that we, the court, got it wrong. But no, what you had was the Republicans giving Obama the great gift of taking guns out of the 2008 political campaign and allowing him to win. Now, obviously that's an oversimplified analysis, but I think what it points to, and I don't think this disconfirms realism, but it disconfirms a certain crassly political form of realism, where realism sometimes is described as what Jack Balkin and I called low politics. What will help my political party tomorrow? It's not that I think the Supreme Court never thinks that way, but I think they almost never think that way. I do think they think in broadly ideological terms, and they think that those views held by the Republican Party or by the Democratic Party are generally good for the country. I would also offer the same distinction between high politics and low politics with regard to racial gerrymandering. I think it is very, very clear that racial gerrymandering, by and large, is a gift to the Republican Party. But you could never tell that from the lineup in the Supreme Court.
Right. Going back to Heller for a minute. So, unlike political scientists, I do not. My realism is not really based on partisanship. I mean, it's more that now than it ever was, but it's not. My view is they're human beings who make all things considered decisions, of which partisan politics, sometimes Shelby County versus Holder, sometimes plays a role and sometimes doesn't. But as to Heller, I think my mother was a therapist, and I found it very useful to talk to her about the patterns of Supreme Court justices, because she had some insights that were very interesting. One of which, for the Obamacare case, was Justice Roberts was tired of it being Justice Kennedy's court. And I think that's really true. I really do. I think there's a big part of that there. But as to Heller, and my mother was a feminist, so with that disclaimer, I think if without Roe, there's no Heller. I think there was an emotional need for Scalia, certainly, and maybe some of the others. This is our Roe. If you're going to put Roe on us, we're going to do this to you, regardless of how it plays out politically for the Republican or Democratic Party. I do think there's a part of that there. I think you may disagree, but I think there's a part of, because they are my biggest complaint about literature on the Supreme Court, and this is true. This is as true of political scientists, I think, as law professors. They're human beings. They're flawed. They do things because of feelings.
Yeah, but maybe "but" is the wrong way to begin it. One of the attributes of American exceptionalism is judicial biography.
Yeah.
There has never been a biography written of any member of the German Constitutional Court, even though it's probably, in many ways, the most important and influential constitutional court, except maybe for the U.S. Supreme Court in the world. And so, it might be worth your inviting sometime a specialist on comparative law, or particularly German law, and the rule of law tradition in Germany that allows the court, by and large, to come up with unanimous decisions where people across the political spectrum respect the judges, who incidentally serve limited terms, and where the decisions are thought to be, in some meaningful sense, the products of legal analysis rather than politics
Right.
dressed up
Right.
in
Right.
legal analysis.
Right.
On the other hand, the last time was at the Supreme Court building, which was actually December of 2019 before the lockdown. If you go into the gift shop, you find an entire stand of books devoted to Ruth Ginsburg for
Right.
all ages.
Right.
That is crazy.
Yes.
But I was for a course I'm giving this term on constitutional design, comparative constitutional design, reading a very interesting essay um, on presidentialism. Um, and there's a discussion of Latin American presidentialism and caudilloism. And the offhand comment, which I underlined and in fact wrote down on my computer, that in Latin America, presidentialism and caudilloism leads to political history being biographical. That forget about presidents who are really confined by the Constitution, who are merely Whiggish, faithful executors of the law. you know, the highest of all bureaucrats, but nonetheless, they're merely bureaucrats. And why would you necessarily find them particularly interesting? You find caudillos interesting because they had, to put it mildly, very capacious understandings of their positions. Constitutions weren't all that important to them. And so I started thinking, and I wrote in the margin, well, what about the American predilection for judicial biographies? And there are already, I think now, at least 3 or 4 biographies of Scalia. I assume there will be more. I think there are a couple on Kennedy. Ginsburg
O'Connor.
has now promote. Yeah. Why do we do this? Because from one perspective, judges should be like David Souter, really uninteresting, viewing themselves as faithful servants of the law and nothing else.
Yep.
So that
yep.
unless you're a legal academic, you probably don't even remember David Souter's name. And I don't know. I mean, I'm sure there's at least one PhD dissertation on Souter because he was on the court for 20 years. But I don't think that any of us are leaping to write a biography of David Souter.
Right. Susanna Sherry, who I think is a wonderful and thoughtful thinker, wrote an article last year or 2 years ago about the problem of Supreme Court celebrity. And she thought it was
terrible.
The article was terrible, or the celebrity is terrible?
The celebrity is terrible.
Yeah.
No, that Antonin Scalia fundamentally rewrote the job description of what it meant to be a Supreme Court justice. And we come back to politics. He came to the correct conclusion that almost nobody reads Supreme Court opinions,
right,
except lawyers and legal academics. Lawyers interested in very specific areas,
and law students,
and legal academics who teach this stuff. But if you really want to be effective, you have to change the hearts and minds of the mass public. And that's what he really did. So his opinions were not written to his fellow justices, whom he often treated with contempt. They were written for law students in terms of getting their attention. He was a very skillful writer, very good polemicist. And then he went on the road constantly. He was always campaigning. And Breyer, interestingly enough, And I don't think it's Breyer's natural personality to go on the Larry King show or to come down to Texas and to debate before, I think, 5 or 8,000 people at Texas Tech with Scalia on originalism or
Right.
the court or
Right.
something like that. But to Breyer's credit, he realized that he ought not give Scalia an open track. It was really necessary and proper to compete with him in the court of public opinion.
Yep.
Now, it's interesting in the present court, there's been no real successor to Scalia in terms of kind of indefatigable campaigning. But nonetheless, you could certainly draw a curve or a histogram as to which judges are more likely to speak in what you and I would regard as politically freighted contexts, and the ones who don't. Interestingly enough, for whatever reason, Kagan is not a regular before the American Constitution Society.
Yeah.
I think she really rations her public speeches. Alito, on the other hand, can be a political hack.
Don't get me started, Sandy. Alito went around the country 3 years ago. I documented this, talking about the threat to religious liberty while the Masterpiece Cake Shop case was finding its way to the Supreme Court.
Right.
I document.
Adam Liptak has an interesting sidebar in yesterday's New York Times, actually based on an article by Posner's son Eric and Lee Epstein on how the Supreme Court has simply done a U-turn over the last 2 decades in so-called religious liberty cases.
Yep.
But that too, I don't know that there's any celebrity on the current U.S. Supreme Court to compare with Ginsburg or Scalia.
Agreed.
And I don't think Roberts ever does anything particularly interesting in public except make his understandable but ridiculous intervention last year or a couple of years ago that there are no Obama judges or Trump judges, that we're all umpires calling balls and strikes. Now, I don't think he really believed that, but I could understand why, as Chief Justice, he thought it was useful to say that.
His year-end reports, which, by the way, I find this interesting. Every year on December 31st, he does a report of the judiciary, which journalists get like at 1 o'clock in the afternoon, but it's embargoed until 6 o'clock, which raises all kinds of issues by itself. But leaving that aside, you fall asleep after 3 lines. He's done like 15 of them. Right. They're so dull.
Well, except when, I forget when, shortly after he got to the court, where I think it's fair to say, I don't think it's simply snarky to say that he traded a roughly $1 or $2 million income for, I think it's something like $250,000 income. He organized his message around the so-called constitutional crisis of low judicial salaries.
Right.
Now, as a matter of fact, I think we probably do underpay certainly public servants in general, and maybe even judges in particular. But I don't think that is the greatest crisis facing us. I'm sure that the public defenders Joe Biden just nominated to be on the federal courts will appreciate the pay raise they're going to get, and where I think they will get as district judges merely about $175,000 a year, which will place them well above the median.
We have to end this in a couple of minutes. I want to say one thing, then ask you one last question. I think it was 2012, but I'll be corrected if I'm wrong, when people were upset that the Obamacare case wasn't being televised, and I've always, and cameras in the court was a big, and Roberts wrote a year-end report talking about pneumatic tubes and how we it's our job to go slowly, and it's our job to, and he gave a whole history of pneumatic tubes, and I was like, are you kidding me? All right, Sandy, one last question because we've gone over anyway. Just give me 5 minutes on the play you wrote, how that came to be. It's now a movie on Amazon. And
No, it's not a play that I wrote.
Okay.
That I know it's very, very important. Heidi Schreck wrote it.
Okay.
What the Constitution Means to Me.
Yeah.
What is true is that as the result of sheer contingency, lightning strike coincidence. First of all, my wife and I co-published a book or co-wrote a book called Fault Lines of the Constitution.
Right.
That is ostensibly written for teenagers. But I always point out that it's fine with me if grandparents, parents, aunts and uncles, and everybody else reads it as well, because it really lays out in what I think, because my wife is a very talented writer, far more so than I am, lays out in very accessible ways problems in the US Constitution. So that in fact, I have assigned the book to Yale law schools. And I think the book worked. And it's also available. This is the commercial.
Okay.
It's also available in a graphic novel version that was published last year. So at NYU Law School in 2017, just after the first edition of our book came out, Mava Marcus organized an event for social studies teachers in New York and Connecticut to spend the day talking about the book and how it might be integrated into the teaching about the American Constitution. Because as you know, I think legal education, I think it's pathological. We grotesquely overemphasize the importance of rights provisions,
Right.
and pay almost no attention to structural provisions, because the structural provisions that are most important are never litigated.
Right.
So as far as legal education is concerned, the structural provisions may as well not exist. So there we were at NYU. Heidi was there because at that time she was writing her play, somehow or other had heard about this program and decided to attend. And everybody in attendance got a free copy of the book. So she read the book, and it influenced her in the last 12 to 15 minutes of the play, which is a debate about, using her terminology, not mine, whether the US Constitution should be abolished.
Right.
I would settle for radically reformed. No, doesn't matter. The narrative arc of the play, which is wonderful, and it is available either on Amazon.
It's
or
Amazon
Netflix.
Prime. I checked. It's Amazon Prime.
Yeah, I mean, it's a wonderful play. Everybody should watch it. The narrative arc is that she begins as a 15-year-old winning American Legion contest after American Legion contest on what the Constitution means to me, which obviously is celebratory. She gets enough prize money that it pays for her to go to college. And she wasn't cynical. She really did love the Constitution. And then the narrative arc is how, as a feminist, she becomes radically disillusioned with the American Constitution because she views it, debatably or not, as having nothing in it for women. And then, as I say, it concludes with a debate between Heidi, and she starred in the play on Broadway
Yeah.
and in LA and on the Amazon Prime version, and a 15-year-old phenomenally good debater. Now, there are different 15 or 16-year-old phenomenally good debaters who play that role. We saw one of them, I think she was then 17. She was going out to Trinity College in Hartford. So on the Amazon Prime version, there's another phenomenally good debater. What they do is to pick a number from a hat each night as to who debates abolish it or keep it.
Huh.
And it really is very interesting. And so she drew on our book for some of the reasons. In addition, I mean, interestingly enough, our book brings up the issue of women's rights in a specific chapter on Article 5 and the near impossibility of amending the Constitution. So the heroine, and I certainly use that in quotes, of that particular chapter is Phyllis Schlafly,
Of course. Right.
because she figured out that with a lot of skillful political organization, she could prevent the ERA from happening because Article 5 gives unconscionable advantage to those playing defense in the game of constitutional amendment. And we indicate that the ERA had majority support. My own view is that I wish the ERA were in the Constitution, but also, quite frankly, that if you are a lawyer with a capital L, it doesn't matter that much one way or the other, because you can get wherever you want to go through the 14th Amendment.
Yeah.
Full stop.
Yeah.
So,
I
but
will say
but
that Noah Feldman says in his casebook, I have not confirmed this, that we're the only Western country in the world with a constitution that doesn't have a provision for equal rights.
Sure, and we ought to. We're the only constitution now in the Western world, or any constitution written since 1945, that doesn't include medical care or
Right.
education.
Right. Right.
So, I mean, I'm not opposed to the ERA, and I share Heidi's dismay that Phyllis Schlafly was able to prevent it because of this really dreadful and indefensible aspect of the US Constitution called Article 5. But she gets the credit for the
Okay.
play. Cynthia and I are really, really pleased that she happened to be in Washington Square that day in October. And what that led to is that she wrote a great blurb for the second edition of our book that came out in 2019. And Cynthia and I got the opportunity to do a talk back on Broadway
Oh, that's awesome.
in May of 2019,
Yeah.
following one of the productions. So
Right.
I've argued a case before the U.S. Supreme Court, and I've been on Broadway. What more can one ask?
Well, I just want to say that we started with Article 5. We're ending with Article 5, which is a good thing to do. And I do want to say, Sandy, in all seriousness, that your voice, really, for my entire career, which is 30 years, your voice has been really important. And I want you to keep at it and keep doing these things and keep shaking things up, because I really think you've made a difference. I say this seriously. You've made a big difference to me and a lot of the 60-year-olds, was one generation behind you.
Kids.
And
you're very kind.
It's true.
And
it's true.
I hope that some of it is true.
It is.
But I've certainly enjoyed being here. And wish we could go on forever.
Yeah, thank you so much. Me too. I wish we could too. Thank you so much, Sandy. And after COVID is over, we'll see each other at some point.
Yes, I look forward to that.
Thank you very
Good.
much.